I'm the big man attorney, Joey Franks, with Big Man Law here in Jackson, Mississippi. And today we are going to go see Judge Simpson. Finally, a change up. I love Judge Middleton, but I also like a little variety. This is a fun one. It's a DUI. It's my favorite area of criminal defense. And I'm going to let you go to it and go ahead and hit the like and subscribe button, especially if you like being the judge.
Court calls case People versus Anika Skip.
Mr. Reiser, on behalf of the people.
However, on behalf of Ms. Skibb, who is approaching the podium. Ms. Skibb, please introduce yourself to the court.
My name is Annika Skibb.
Yes, I mispronounce it every time.
Okay.
Thank you, Your Honor. Your Honor, today's the date and time set for pretrial and violation of bond. As to the, would the court prefer to address the bond violation first?
Hold on a second. Got it. Okay, go ahead.
Would the court prefer to address the bond violation first or the pretrial?
Bond violation.
So, Your Honor, at this time, Ms. Skibb is not going to contest the violation. She is going to admit the violation for drinking and testing positive on the silver link.
And Skip, why?
Your Honor, I'm very ashamed because this mistake was absolutely not indicative of the work I've been putting in the last few months, regularly attending meetings, and I'm very involved in the AA community in this area. I did an assessment by First Step Referral Services and was advised to complete inpatient treatment, and this is not at all acceptable, but the idea of having to be away from my son and the stress of this case on me, I allowed it to get to me, and when I messed up, I panicked, but I am currently at Dawn Farm.
Do I have the violation?
And it is the 90-day program, correct? Yeah, so she's in the gold standard, the big one.
Well, I'm looking for my copy of the. I may have it. Was it from
February 20th.
No.
I think that's the date of the violation that I have. Whether the report is dated the 20th, yeah.
That's what I saw. How much were you drinking?
The day of the 20th, so the first day, I believe I had
The day of the 20th?
The day of the 20th is when I thought the report was sent from, Your Honor.
No, Ms. Gibb, have you seen the bond violation report?
I have not.
Have you had a chance to look at it? We discussed it, Judge, but we haven't.
Sorry, I was thinking about the 18th, Your Honor.
Yes,
On the 18th,
Yes.
you blew a .12.
I had 2 drinks. Was immediately after, I believe so. I had, I believe, 2 drinks, possibly 3. I don't remember exactly.
Then immediately after that, basically through that was at 10:33 when you blew those numbers. And then basically into the early morning of the 19th, you missed your testing.
Correct.
Are you indicating to me on the 18th, you had 2 drinks?
No, Your Honor, I'm saying I don't remember how many. I believe it was 2 right before breathalyzing. I believe it was.
And then how many did you have after that?
Again, I don't know. It was a few drinks the next day as well.
What?
It was at least a few drinks the next day as well. I don't remember exactly how many, Your Honor. I'm sorry. I didn't measure.
Because then at 2 o'clock that next day, PM, you blow a .09.
Correct, Your Honor. Like I said, I panicked and I was drinking for the next day, so.
You kept not retesting as it's required. And then by 9 o'clock that night, you blew a .267. Mr. Allen. And you say now you're in treatment?
Yes, I'm currently at Dawn Farm and I was in jail for 6 days.
Anything else you want to say?
Your Honor, Ms. Skip has been very honest and open with me about this and about her problems with her drinking. She is like I said, she is at Dawn Farm. From my understanding, I believe it is going to be effective, and correct me if I'm wrong, eager to get back on track. She is deeply regretful and remorseful of her mistakes. She's been honest with me the whole time, and I don't believe she's tried to hide this at any point. But we are asking that, Your Honor, that she be allowed to return to Dawn Farm rather than the custody of the county today.
And then what will I do with her?
And I suppose let's see what happens at Dawn Farm after 90 days. She is inpatient. It is inpatient, Judge, if that makes sense.
Do I have it?
I'm sorry.
Do you have proof of that?
We don't have any. Do you have the written documentation here right now?
I have, so I have documentation from the farm with me. I also signed a legal release of information to Mr. Bradal on Monday when I was admitted. I also
Right now, I don't have anything.
I have a peer with me that's from the farm that is also with me. If possible, we can call the farm. Whatever proof is needed, I will be able to get to you today. I didn't realize that I needed more than the legal release of information.
Well, somehow or another, that information has got to get to me, but this, based upon the violation that I see, defendant's bond is revoked. I'm going to remand her to the Washtenaw County Jail. I'll set it out 1 week during the sentencing and review that, but right now it's revoked. Defendant's remanded.
Understand.
This woman, her story, it kind of changes. And you trust pinning her down how many drinks she's had, because at one point she blows a .12, which is above the legal limit in any state that you can think of at this point. Back in the old days, the limits used to be a lot higher, but the feds have gotten it down to a .08. They hold that grant money right there, so they got you. So she blows a .08 and says, well, I had 1 or 2 drinks, and then it goes up to 3, and then it's before she blew, and things like that. I'm here to tell you, 2 drinks don't get you to .08. Unless they were very, very, very stout Long Island iced teas, no thanks. And she said, it happened immediately. You gotta remember again, drinking is a bell curve. So if I took 3 shots, hopped in my car, and drove 5 minutes down the road and got pulled over, I probably wouldn't blow a .08. Now you fast forward that out 20 or 30 minutes, yeah, I'm on that high side of that bell curve, or on the upside at least. But she says I might have had 3, and that's like on the 18th. And then on the 19th, she misses some stuff. And then it's not clear if it's the 19th or the 20th. She blows a whopping .267. Well, let me tell you, you got some problems at a .267, like legit physical problems. You are impaired in every way that a person can be impaired. I'll see about getting a chart to link or drop up here so you can kind of see what I'm talking about. But some of the problems you're looking at are consciousness and incontinence at that point. She legit has a problem. And the one thing this woman's really got going for her, she's not screaming up and down like I'm hiding it. No, she says, I got stress. I took it out the wrong way. I went back to drinking. You got me. I'm not even fighting the bond violation. So she gets points there, no doubt about that. But you can't drink for stress. You can't, this is a major misconception that people run into. One, I support folks going to rehab 100%. I understand the low success rates. I also understand that it becomes statistics after you go so many times. The chances of it taking tend to increase a little bit. But the time to go to rehab is right after you get arrested. You don't wait until you've gotten arrested. You've got a bond violation. You've got all these things stacking up, and as court approaches, you go to rehab. That doesn't look good. It looks like you're going to rehab to get out of facing the music. So I don't like when people do that. But I applaud her for trying to get help. She's getting inpatient help. It doesn't get much more serious than that. Judge Simpson. How does he rule? Well, he sends her to the back. She gets to wait a week until they can show proof that she's actually going to an inpatient clinic. It seems this attorney didn't quite have all the ducks in a row. It's best practice to show up with all the paperwork so that nobody's questioning anything. You're just bam, 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 almost like dealing cards sometimes, except you're dealing it in 8.5 by 11 sheets. And if you keep that going, it's one, very impressive because people realize you got your stuff together, and two, it's very beneficial to your client because there's no question about anything. So it seems like he could have done a little bit better on that, having that squared away. But Simpson's going to see her back in a week and take it from there. How would you rule on it? You're the judge here. Hope you put it in the comments. Tell me everything, because I love this stuff. I love hearing how you would handle it as the non-lawyer, which in Mississippi, by the way, some judges aren't lawyers. Go check out our justice court rules. In this one, Simpson was a little on the tough side of things here. He sent her to the back for a week when they could have verified that paperwork pretty quickly. I understand what he did. I don't think I'd have done that. I think I'd have bumped her to the bottom of the docket and said, hey, call them up, get them to fax it to the clerk. Let's get the paperwork and let's send them on her way. Simpson's got a real problem about what's he do with her once she gets out. I would argue once she gets out of the inpatient treatment, put her back on a bond and set her date for trial and go have her trial date. If the prosecution's got a recommendation, well, it's her option whether she wants to go that route or not at that point. Again, love to hear your thoughts. Let us know. If you haven't liked it, you're still here. You should probably like it and subscribe to us. I appreciate it as always. Have a good one. See you next time.